Got a party wall letter through your door? Bad news, it's not a party and there's definitely no cake. Good news, we're here to explain what it actually means. I'm Faye, Director at Clarke Chartered Surveyors. Whether you're a homeowner planning to extend your kitchen or a neighbour worried about next door's loft conversion, understanding the party wall process can save you time, money and quite a few headaches. In this video, we'll demystify the Party Wall Act, break down the process step by step, and explain how a surveyor can help you navigate it all smoothly. So let's start with the basics. The Party Wall Etc. Act 1996 is a piece of legislation that provides a framework for preventing and resolving disputes in relation to party walls, boundary walls, and excavations near neighbouring buildings or structures. But what is a party wall? To confuse matters slightly, there are two types of party walls. The first is often referred to as Type A and is a wall that stands on the land of two owners and forms part of a building or simply separates two buildings. Think of the walls between semi-detached or terraced houses. Type B is a wall that stands wholly on one owner's land but is used by two, or sometimes more, owners to separate their buildings. A good example of this is when a building is built up to the boundary or line of junction and a neighbour has later constructed a new extension and enclosed upon this wall. This is a situation where the wall was not initially a party wall until the neighbour built their extension, enclosed upon it and made use of that wall. But the Act doesn't just apply to walls. It also covers work on shared structures, like floor structures between flats, and chimneys, building new walls at the boundary or line of junction, excavating near a neighbouring building. In short, if you're digging foundations close to your neighbour's property or carrying out works to a wall or structure you share with someone else, chances are that the Act actually applies. Ignoring it can lead to legal disputes, construction delays, or even an injunction to stop your project altogether. That's why getting this right matters. If you want to know whether your works are notifiable, give our office a call and ask to speak to me directly. I'm more than happy to help. So when do party wall matters actually crop up? There are typically three common scenarios that we see regularly. Loft conversions, especially when steel beams are inserted into a shared wall. Extensions, particularly if they involve excavating close to your neighbour's property or building at the boundary. And basement works. Deeper works require much more detailed notices and often spark more disputes or concerns with neighbours. You might also need to notify your neighbour if you're repairing a shared wall. Common issues we see in Portsmouth are repairs to leaking firewalls above the roofline, raising a shared wall, common again in loft conversions with dormer roofs, or excavating within 3 metres or 6 in some cases of a neighbouring building. But here's the key point. The person doing the work is responsible for serving notice. While you can, and in our opinion should, instruct a surveyor, the responsibility to ensure notice is served lies with you. Even if the work seems minor to you, it could affect your neighbour's property and fall under the Act. Failing to notify them properly is not just bad manners, it could be unlawful. So let's go through the step-by-step process to the Party Wall Act. Firstly, you must give your neighbour written notice of your proposed work. There are different types of notices depending on the work. It could be a line of junction notice, a party structure notice, or a notice of adjacent excavation. The notice will need to be served at least 1 month before carrying out excavation works or building new walls at the boundary, and at least 2 months before starting any works affecting a party wall or party structure. Your neighbour can respond either by consenting to the works, great news, as you won't need to pay for surveyor's fees for dealing with an award, or they can dissent, which triggers the need to appoint surveyors. If they don't respond within 14 days, it's treated as dissent by default. In this scenario, a further notice will need to be served, giving your neighbour a further 10 days to respond. Should your neighbour dissent, each party can appoint their own surveyor, or agree on a single agreed surveyor to act impartially for both. The surveyor's role is to act independently, not to side with either neighbour. It's worth noting that you can use your neighbour's chosen surveyor as the agreed surveyor. It doesn't just have to be the building owner's chosen surveyor. Once all this is completed, the surveyors can prepare a legal document called an award. This sets out what work will be done, how and when it's carried out, any protective measures like temporary weatherproofing of a party wall, access arrangements if it's appropriate, a schedule of condition of the neighbour's property, associated drawings, costs, who's paying for what, and much more. Then, once the award is served and that 14-day period has passed, work can begin, assuming you followed the agreed terms of the award and your neighbour has not appealed the award. Party wall notices must be clear, accurate and correctly served. A common mistake is trying to DIY this and missing key information, drawings, or getting the timings completely wrong, which can invalidate the notice entirely. If there's a disagreement, don't panic. The Act provides a dispute resolution process via the appointed surveyors. These surveyors will work together or independently to agree, prepare and serve a fair award. But remember, there are some points that you need to think about. An award can be appealed in the county court within 14 days of service. If you damage your neighbour's property, you'll usually be liable to fix or pay for repairs. This is why schedules of condition are so important. Disputes are often avoidable with good communication. A quick chat before serving notice can go a long way. But how can a surveyor help you? A party wall surveyor does much more than paperwork. We help interpret drawings to determine what parts of your works are notifiable, advise you on the best way to serve your notice, and talk to your neighbours about their concerns. We draft valid, accurate and compliant notices. We agree fair terms that protect both parties, and we will record a detailed schedule of condition to avoid any blame games. We will resolve disputes efficiently without heading to court. And whether you're carrying out the work or just want peace of mind as a neighbour, our job is to protect both parties' interests and prevent conflict. And let's be honest, sometimes it just helps to have a calm, expert voice in the mix. So, whether you're planning building work or reacting to a notice through your letterbox, remember, the Party Wall Act is there to protect everyone. The process might seem formal and yes, a little bit daunting, but with the right guidance, it doesn't have to be stressful. If you're unsure about your rights, your responsibilities, or your next steps, our team at Harris & Clarke is always here to help. Got questions? Drop them in the comments or get in touch directly. We'd love to hear from you. Thanks for watching, and don't forget to subscribe for more surveying insights and check out our website if you want to know more.